Evening, ladies and gentlemen, and welcome to Vasant Vihar Club's Spring Fest 2022, a virtual online fest of thoughts, perspective, and culture. Today's session is Religion, Constitution, and Judicial Activism. We have with us on our panel today Justice Kurian Joseph, Advocate J. Sai Deepak, Shiv Khera, an educator, a business consultant, author, and motivational speaker, and Neeraj Grover, our moderator, who is a lawyer at the High Court. But before we start the evening's proceedings, I would request the President, General Shankar Prasad, to welcome our panelists and say a few words. General Prasad, over to you.
Thank you, Sanjana. Good evening, ladies and gentlemen who joined the program, and my special welcome to Justice Joseph Kurian, to Mr. Shiv Khera, Advocate J. Sai Desai, and to our very loving moderator, Neeraj Grover. Ladies and gentlemen, as Sanjana said, that since about 2016, we have been having these literary festivals in the months of March and April. And unfortunately, this year we couldn't do it in time because of the pandemic. Even last year, even though pandemic was in full form, the committee was able to do a very fine lit fest on the Zoom, on what they call the virtual net, and it was a great success. We had people participating from all over the globe on that particular session. But this year, because of two reasons: firstly, the pandemic, and second, the financial crisis that we are going through, we decided not to spend any money at all and yet do something to keep the activities alive. So we are doing a virtual lit festival with very limited numbers. We are just doing about 1 or 2 a week and spread over the month of March. And this is one of those programs which is, I think, the second or the third program, really. You must be wondering why we chose how do we choose these programs? You know, when we look at the newspaper, we find various activities reported every day. Newspapers, when I mean say newspapers, I mean media. And particularly newspapers, every morning when you pick up a newspaper, you find that there is at least 15% of the news in the newspaper concerns the judiciary, whether it is the lower courts or whether it's the high courts or the Supreme Court. And there are all kinds of debates on judiciary at various forums, particularly when it starts appearing in the media. So we decided to do a program on legal matters, and we could have none better than Mr. Justice Joseph Kurian. Most of us know him, may not have physically or personally met him, but if I remember the date correctly, Justice Saab, it was, I think, 19th of January when you really hit the headlines in India. In the year, I think, 19th of January, if I recall?
12th.
12th of January, all right, 12th of January. In 19 or 18?
18.
18. So then from that day, just nobody in India can forget Justice Joseph Kurian. And so we found that he lives in Vasant Vihar and a very cooperating member of our society here in Vasant Vihar. So we decided to invite him, and he very kindly agreed to come on the program. Kurian Saab, thank you so much. We are ever so grateful to you. I mean, your arrival on this platform, on this program today has really made this program worth the while. And we really look forward to some interesting aspects from you, not only restricted to what we have given out in the heading, but anything that you think needs to be discussed or bring into public forum. And we have a very firebrand, if I may use the word, Advocate J. Sai Deepak. Although I've not met him before, but he's a very vibrant constitutional lawyer, and I think all of us need to really listen to him and what he has to say on various matters. And he's recently participated in some very critical decision making relating Sabrimala and some other matters. So we look forward to listening to you, Deepak. I wonder how we were to be addressed. Do we address you as Deepak or Jay or Sai, whichever is? Sai is the way to address you. All right, Sai. So we look forward to some firebrand arguments today. Not in a courtroom, though, but over here on our platform. And of course, Mr. Shiv Khera. Nobody in this country or the world doesn't know Shiv Khera. Shiv Khera is one of the finest speakers you can ever come across. He speaks on matters relating to public matters. He has been a great vociferous issue on the constitutional matters. or legislative matters. But interestingly, Justice Kurian, we have these three, what you call the pillars of the Constitution, which is the legislature, the executive, and the judiciary. And of course, the fourth fellow has got into it called the media. And there is trial by media all the time. So I don't know how much it motivates or manipulates the court's decision, but that's one aspect which appears in the newspapers quite often. Then there is this legislature. And I was just listening to some debates and I discovered that 20 bills got passed in 5 minutes in the parliament. Now, is that what legislature is supposed to be really doing? So that's an interesting part of legislature. And when you look at the executive, you find that, there is some kind of what should I say, not a scare really, but once a democracy has a very strong leader, then the executive has a role to play, which is quite different than what perhaps it's designed for. So that's not the real debate, but I just thought that introducing this subject, this is just to put in perspective as to how we decided to choose this subject. And then we listen to some views. And of course, we have a fantastic moderator, another firebrand young advocate of the High Court, a resident of our Vasant Vihar, and a member of our managing committee. He's also the legal advisor to the society. And I have no doubt that he'll conduct this discussion in a manner which will make all of us really very interested in it. So over to you, Neeraj.
Thank you so much, sir. In fact, as Sanjana ma'am and General Prasad has already touched about today's topic, we are going to discuss on a very interesting topic. We are in perhaps the 72nd year of our constitution coming into play, but still as a vibrant democracy, the constitution is evolving as of now, and it will continue to evolve. We will have different perspectives from different people, and as a democracy, we are bound to go to a better and a progressive approach to it. Be that as it may, to enlighten us on the topic, we are privileged to have a very, very illustrious panel today. You all can see my three panelists here today. I'll just very briefly introduce each of them and then open the forum. Justice Kurian Joseph is a retired judge of the Supreme Court of India. Justice Joseph has served as acting Chief Justice of High Court of Kerala twice and was subsequently appointed as the Chief Justice of High Court of Himachal Pradesh in the year 2010 till 2013. And he was elevated to the Supreme Court of India in March 2013 and retired from the Supreme Court of India in November 2018. He disposed of almost 66,000 cases while he was the judge of the Kerala High Court, around 15,000 cases in Himachal Pradesh High Court, and over 8,700 cases in the Supreme Court. He has been a part of few constitution bench judgments, and therefore we can find no better panelist today than him on the panel. Since retirement, Justice Joseph has been focusing on ADR processes such as mediation, arbitration, and conciliation to support parties to find sustainable and long-lasting solutions. He is routinely appointed by the Supreme Court of India and various high courts to act as a mediator and an arbitrator. Justice Joseph is also on the panel of mediators at Singapore International Mediation Center, which is one of the world's most renowned mediation centers. Mr. Shiv Khera, as everybody knows, is an educator, business consultant, and author of a book, and his 8 million books have sold, including the international bestseller You Can Win in 21 languages. He has taken his dynamic message to opposite sides of the globe from USA to Singapore. He inspires and encourages individuals to realize their potential and has many Fortune 100 companies as his clients. Over 100,000 people have gained from his workshop, and millions have heard him as a keynote speaker in almost 20 countries. J. Sai Deepak is an engineer turned litigator. He's an arguing counsel with a bachelor's degree in mechanical engineering from Anna University and in law from IIT Kharagpur. He started his legal career as a litigator in July 2009. Apart from high-end commercial litigation, J. Sai Deepak has contributed significantly to landmark decisions such as Tata Sons versus Greenpeace, wherein the law related to interplay between constitutional freedom and IP rights was laid down. He also argued before a constitution bench of the Supreme Court in the Sabrimala temple entry case. He has also been the counsel in Padmanabha Swamy temple case on the 26th Amendment to the Constitution. He recently argued on behalf of Men Welfare Trust in the recent controversy regarding marital rape before the Delhi High Court. Last but not the least, he is the celebrated author of the bestseller India, that is Bharat, Coloniality, Civilization and Constitution, a book which has really brought out the sentiment whether we are today governed and we are bound in the old colonial practices, or we as Bharat today are bound to come out of those foundations. So now, with this background and introduction of our panelists, everybody knows today's topic. I'll just give a very brief note about the topic. Constitution of India, as we all know, guarantees secularism as one of its basic features. The Constitution further guarantees every citizen of India a right to equality and non-discrimination on grounds of religion, race, caste, sex as fundamental rights. At the same time, the Constitution guarantees right to freedom of practicing, professing and propagating religion of their choice. The Constitution of India has been backbone of the Indian democracy and has survived the test of times. Yet in recent time, some interesting issues related to religion and constitution have reached the Supreme Court, and the Supreme Court has been faced with the task to strike a balance between the two while maintaining a progressive view. While urging the Supreme Court to interfere in some religious practices, the principles of constitutional morality have been pressed into service, whereas there is another thought process according to which interference in religious practices amount to judicial overreach. The debate on this topic is endless, and I'm sure even today, unless we restrict some times of the debate, it would still be endless, and that is the beauty of our Constitution, that it continues to evolve even today for betterment of its citizens. Now, with this background, I would throw open the panel. Just for the panelists, what I'll request each of the panelists to give their views maybe in around 7 to 8 minutes on this topic. After we are done with the views of all the panelists, we'll throw open the panel again for some comments as to if the discussions as they are live go on, and then we'll take some questions. I would request the audience not to unmute themselves during the entire discussion, and if any questions are to be asked, please put them in the chat box, and we'll try to take as many relevant questions as we can after the discussion at the end of the discussion. Thank you, everyone. And may I now request Justice Joseph to throw and enlighten us on the topic for today. We know we are all today, I presume we are all a very the audience here is raring to listen to you, sir. And as against the popular beliefs in the newspapers and media, we would want to know what are the constraints when Supreme Court actually gets into these issues and the Supreme Court decides these issues for progressiveness of the entire country.
Thank you. Thank you, dear Neeraj. Beloved Mr. Shiv, Sai Deepak, General Shankar Prasad, Dana, and my other sisters and brothers participating in this webinar. Thank you for inviting me to this program. We have 7 minutes and to cover ocean. But I'll give you just an idea, and then we'll have the rest for the discussion. Because all of us are senior, many of us are senior citizens, so I understand the program is for 1 hour. We have to finish it also. Yeah. See, just to start with the judicial activism part, whether Major put it. Why judiciary is active? Why there is called something called judicial activism? I can only say when there is a passive legislature, when there is a passive executive, the judiciary will be active and has to be active and should be active. Why? Because it is the guardian of the rights of the people. It's a guardian of the constitution. It's actually the highest court in the country, the Supreme Court of India. Coming to that part of the religion path, and Mr. Grover touched about secularism. It's good to have some idea as to what secularism is. That is unique to the Constitution of India. The simple meaning of secularism is, the state does not have anything to do with the religion or beliefs of the people. So, as far as Indian concept of secularism is concerned, it's not that indifferent to religion. It's a pro-religion secularism. I'm just giving you only the natural ideas because my time is only 7 minutes. Whereas in many countries across the world, secular they are. And they say they have nothing to do to religion. That is a totally different business altogether. But as far as India is concerned, because our tradition is wholly different. Because we have given birth to the world known religions, Buddhism, Jainism, Sikhism. And this country has welcomed the world, all world known religions, Christianity, Islam, Zoroastrianism, and whatnot. So we have a constitution where it secures your or our freedom of conscience. That freedom of conscience permits you either to believe in God or to be in to be a follower of a religion, or not to believe in God or not to follow any religion. But as Grover said, if you believe in a religion, there is a fundamental right under Article 25, and which is preceded by the preamble or principle of liberty of thought, expression, faith, belief, and worship. With this, we have Article 25, where it is, given expression in better terms or more vocal terms, where you have a right to profess, practice, and propagate the religion that you belong to. But the problem in our country is people profess religion, people propagate religion, but the middle P is missing, practice. What the constitution of the country expects is, that which you profess and that which you propagate, please, that which you practice, please propagate. But we all sell our ideas without practicing them. That's the whole trouble with this country. That is as far as religion is concerned. Therefore, secularism is a basic feature of the Constitution of India. Having said that, I'll just mention what is a basic feature. Basic feature means something which nobody can amend and take away, because it is so fundamental, it is so basic that the moment it is taken away, it will collapse. The country, the nation will collapse. That's the basic feature. Having said that, I will also, since you're all educated people, this word secular was not in the Constitution when it was originally introduced in the when it's drafted in 1949 and came into effect from 1950, January 26. Why? It was not found necessary to say that it is so. I don't have to say I'm a man. You don't have to say you are a woman. It's so implicit and explicit, both. But after 25 years of governance of this country, in 1977, and that was something very interesting during emergency, and the 42nd Amendment of the Constitution of India, it was felt necessary that it's better to spell out, not for India, but for the whole world to know that India is a secular country. Therefore, secularism and socialism, both were introduced. But having said that, the Supreme Court thereafter said that secularism is a basic feature of the Constitution of India, like democracy, like rule of law. This is a basic feature of the Constitution of India. Therefore, no parliament with howsoever brutal a majority cannot amend and take away this basic feature or basic characteristic or identity of the people of India or the Constitution of India. This is so unique a feature. That is something called basic feature. Basic structure, I must correct it very correctly, because Supreme Court is now trying to, rather the people like Jai would be and Grover would be arguing there's a lot of difference between feature and the structure. So this is actually a basic structure. Feature is different from structure, I agree. But once it is held to be a basic structure, you cannot remove it. Like the Vasanthi Vihar Club, there is a column which is a fundamental column. So it's part of the basic structure. Once that column is removed, probably the whole building will collapse. So it's so basic to the structure of the nation, structure of the constitution, that it should be there. Having said that, I also tell you, but for this constitution of India, India would not have been India like this, because it has taken care of the haves and have-nots. It has taken care of everybody. Howsoever low you are, howsoever high you are, howsoever poor you are, howsoever rich you are, irrespective of your caste, color, creed, religion, sex, language, place of birth, whatever it is, irrespective of, all of you have, this is my definition of democracy. All of us have a space in this nation, and all of us have a voice to raise. This is the essential feature of a democracy. But for that, the moment I am denied my space in the nation, this country ceases to be a democratic country. The moment my voice is suppressed, this country ceases to be a democratic country. So that is something very peculiar. And in the Constitution of India only, we have something called, we have in the constitutional values, we have one justice, which is social, economic, and political, liberty of thought, expression, faith, belief, and worship, equality of status and opportunity. These are the three slogans of French Revolution. And the fourth one, constitutional value, is fraternity. Fraternity is given as a duty. Fraternity, and there's something very unique about this fraternity. Fraternity assuring the dignity of the individual. Thus, the dignity of individual does not depend on whether you are a man or a woman or a transgender, whether you're rich or a poor, but dignity of the individual depends on whether you are a citizen of this country and you are a person in the country. Because two what you call fundamental rights are available to all persons, not to citizens. That is Article 14, the Equality Clause, and Article 21, the right to life. So, my dear friends, I'm just closing, saying that, we belong to a great nation where these fundamental features of our right to life and human rights are constitutionally protected. It is not the generosity of anybody, the ruler, but it is actually our right to live a decent and a dignified life in a country of diversities. What is the diversity? We have 22 scheduled languages. We have around 2,000 non-scheduled languages. We have all world-known religions. We have different states. We have all world-known religions. Or we have all world-known civilizations, cultures, and whatnot. With all that, even Delhi also, if you travel from one part of Delhi, the other part of Delhi, you speak a different slang of Hindi, but even then it's there. Kerala, we have Malayalam. West, you go to Assami. This side, you go to East, you go to Gujarati. That side, you go to Hindi. And there's a lot of Hindu belt also. Different religions also, with all castes also, tribes also, communities also. With all that, India is India, because there is one constitution webbing us all together. And we should be proud of that constitution, which it teaches us that we have not only rights, but we have duties. And that duty that tells us that India is my country and all Indians are my brothers and sisters. Thank you.
Thank you, sir. Thank you so much for your comments enlightening us. May I now request Sai to give his thoughts over the subject?
Thank you, Neeraj, for this opportunity to participate. And I thank the Vasant Vihar Club for giving me an opportunity to share space with Justice Kurian Joseph and Shri Shiv Khera. In fact, most people don't know that during the Kerala floods, Justice Kurian Joseph was at the forefront for both collection of material as well as helping out people who were affected. So this is an aspect of most judges, most people don't get to see. So these are certain things that I thought people should be aware of. Coming to the topic, let me just try and string it on the basis of the title itself. So as opposed to focusing exclusively on the constitution or judicial activism, perhaps the issue is of judicial activism through the prism of the constitution in the area of religion. That would be the specific issue that I would like to focus on. And therefore, this takes us to certain sensitive aspects. One of the distinctions that I would like to strike at the outset before I proceed with some of my views on the subject is it's important to strike a distinction between India as a secular state and India as a society. The state is meant to be secular. The society is not secular by most definitions. It is a heavily religious society. So therefore, the distinction that you strike between the state and the society is a fictitious distinction for the purposes of the constitution, only because the idea is to ensure that the state, as the guardian of the rights of all its persons, does not tilt in favor of any particular religion, and therefore it imposes upon itself a certain legal fiction, which is that I am secular, which is to say, I am not irreligious, I am not averse to religion. I just hope to treat all religions at par with each other to the best of my abilities, using the constitution as the guiding post for this particular exercise. So that is more or less the definition of secularism in this country. So every time you hear in a public debate that India is a secular country, India is a secular country, India is a secular society, I think you should immediately correct anyone who makes the statement and say, sorry, India is a secular state, but as a society, we are not secular. There's a clear distinction. That's point number one. Point number two is just to add to Justice Kurian-Joseph's point, I completely agree that the word secular was certainly introduced in the Constitution for the very first time through the 42nd Amendment of 1976. But the word secular was previously present as part of Article 25, where it strikes a distinction between religious aspects of a religious institution and secular aspects of a religious institution. So in that sense, neither the term nor the concept were alien as far as the Constitution is concerned, even before 1976. Now, therefore, the question is, what difference does it make when it is added as part of the Constitution, as part of the preamble rather? It effectively ends up taking the position that the preamble is the sar or saransh of the Samvidhan, and that secularism happens to be one of the central features of the Constitution. Now, since it was included in the preamble only in 1976, it gives rise to two kinds of arguments. One is to say, if it did not exist before 1976 as part of the preamble, was it an unsecular constitution before? And second, if it was already a secular constitution without the need for its inclusion in the preamble, where was the need to include it again? Now, was this issue discussed as part of the framing of the Constitution? The word secularism was heavily discussed as part of the Constituent Assembly debates. And one of the reasons that they chose not to include it as part of the preamble, they included it as part of Article 25(2), but they chose not to include it as part of the preamble, is because the word secularism is capable of taking multiple meanings. It has a huge loaded history. In fact, as part of my book, India That Is Bharat, this is not an attempt to sell the book, but since I've mentioned and discussed serious aspects of the origins of the word secularism as part of the book, it comes with its own history. Therefore, one of the fears that was expressed during the course of the discussion in the Constituent Assembly was that if you were to include a vague and undefined term such as secularism as part of the preamble, it is bound to lead to a lot of communal mischief, and that it is capable of creating divides in the society in the name of secularism, which is perhaps a fear that stands vindicated over the last 70 years, is my humble opinion, which is to say that the use of the word secularism as part of the political discourse has now become a weaponized use of this particular concept completely. And therefore, the fear expressed by the framers of the Constitution stands vindicated today as we stand. That's my personal belief, of course. I'm sure there are multiple diverse, let's say, points of view on the subject. 3, going to the question of what is the scope of the state's interference with religion, citing the Constitution as the document, which is to say, can the court interfere with a religious practice, citing the Constitution as the basis for interference? Can the executive choose to do so? And can the legislature do this? Because when you're looking at wielding of powers under the Constitution, you're asking whether any of these limbs are permitted to interfere with religion through the Constitution. If yes, is the scope of wielding of powers by each of these organs different? What most people don't know is that the Sabarimala matter was originally before Justice Kurian Joseph's bench. And then it traveled to another bench. I hope I'm not making a factual mistake. Yes. And I wish I had the pleasure of arguing before Justice Joseph when the matter was before him, because some of his observations there were stellar, which is to say, courts, especially judicial unelected bodies, must be slightly wary and conscious when they choose to interfere with religious practices for one or two reasons. One, agar reform happens to be one of the objectives of a particular religious practice, it is for the legislature to initiate reform. Simply because at the end of the day, it is the legislature that is full of elected representatives. A judicial body, notwithstanding its erudition, notwithstanding the constitutional powers it wields, is still an unelected body. And an unelected body does not, strictly speaking, represent the will of the people. And therefore, a judicial body must perhaps be a bit more circumspect with respect to interference with religious practices. That's one. Second, whenever we discuss the Constitution and religion these days, there is a tendency to pit the religion against the Constitution and make it seem as if religion and Constitution has a versus in between. And I've seen a lot of these public debates being played out on multiple platforms. The fact is, religion has a special and a specific place within the Constitution itself. And therefore, both religion and religious institutions cannot be pitted against the Constitution because they have their own special islands created for themselves. This is not to say that religion cannot be touched by the Constitution. That is not the argument. Religion can be touched by the Constitution. Of course, there are, let's say, powers that the state can wield. But by and large, and I would say so without any exception, the power to interfere with religion is predominantly with the legislature, as I said. That's one. Two, one of the reasons that most jurisdictions are extremely reticent and reluctant and at least careful before interfering with religion, at least as far as the judiciary is concerned, is that if the state is treated as a secular institution, every organ of the state is treated as a secular body, which means it lacks institutional training as far as religion is concerned. So for instance, there are several stalwart judges of the Supreme Court in the history of the Supreme Court who have been masters of religion. For instance, people have been fantastic. Let's say Justice Gajendra Kadkar used to write books on Upanishads. Okay. In fact, their judgments used to be peppered with a lot of quotes from Upanishads, Vedantas, and whatnot. But that only reflects the erudition of a particular individual occupying a particular office, but not in institutional training itself. Okay. So just as you respect the fact that no person can know taxation, intellectual property, constitutional law, criminal law, civil law, arbitration, public international law, and private international law under the sun, and you can't be an expert on everything, and you also believe that these are subjects that require training, theology also requires a specific degree of training and exposure, regardless of whichever religion you may be talking about. So therefore, an unelected body which does not represent the people and which lacks institutional training as far as religion is concerned must be even more circumspect when it chooses to interfere with any practice. Let me clarify that my position is bound to be misunderstood as a intelligent and mischievous defense of any practice. I'm not doing that. I'm not going to sit and justify any religious practice. We are not on which religious practice is good or bad. We are on what does the Constitution permit through judicial activism as far as interference with religion is concerned. So my position is limited to the power of a specific organ of the state to take a decision and sit in judgment or sit over a particular practice. On that, if you look at other jurisdictions, typically what happens, even in America for that matter, whether it's a Christian state or not a Christian state doesn't make a difference. If a court is seized of a question of what is a certain tradition as far as a religious body or a religious institution is concerned, it typically defers to a representative of that particular institution who files an expert affidavit like any other expert on any other subject, like a handwriting expert or a forensic expert. You typically allow people from that particular religious tradition to file expert affidavits to assist the court and say, this is the practice according to us, which means the court has to accept that version and then take a decision whether it wants to uphold the practice or not. The court itself cannot get into a question of what is an essential religious practice because it does not know how to read a subject on the question of religion. What happens in India is that secular constitutional courts enter into the question of what is an essential religious practice as far as a particular religion is concerned when they have no training in that at all. I'll give you a simple example. Since Sabrimala was mentioned, and Mr. Khera, this will be my last point, sir. I know you've been extremely patient. I'll just make this point and cede the floor to you. So on the question of Sabrimala, a lot was discussed on menstruation, a lot was discussed on brahmacharya and whatnot. So I'll give just one example and leave it at that. Between different parts and different directions of this country, Tantra as a philosophy itself has diversity. So for instance, if you go to Assam, Kamakhya temple, it follows what is known as left-handed Tantra and therefore it is Vamachara Tantra. So if you go to Kerala, which has another form of Tantra, it typically follows what is known as Dakshinachara, or let's say the right-handed form of Tantra. In right-handed form of Tantra, typically there are restrictions placed with respect to menstrual practices. But if you go to Vamachara Tantra, menstruation is celebrated and worshipped, which is why the deity in Kamakhya itself is a menstruating deity who is worshipped. Okay. Now assume for a moment that these distinctions are not known to the institution, which is a secular institution. And the person presiding over this particular issue also has no clue whatsoever as far as the distinctions are concerned. And then goes on to speak of equality, feminism, patriarchy, institution, and these typical labels are brought about. The diversity of the institution, the practice itself is completely forgotten. Therefore, in matters of religion, most jurisdictions, because India has a tendency to look at this side of the Atlantic or that side of the Atlantic whenever we have any doubts, well, on both sides of the Atlantic, they typically try and look at expert issues, or let's say expert opinion on matters of religion. So perhaps, because the hijab controversy is still going on before the Karnataka High Court, as opposed to the court getting into these issues, and as opposed to even for that matter, a lawyer making a submission with respect to a particular religion, it would be much better if experts who are trained in those particular subject and in those fields of theology are actually heard. Because I think it would be mighty rich of an institution to say that I must preserve my independence because I know my subject best on the one hand, and still not hear another person who knows his subject best on a particular aspect of religion. Just as you wish to preserve your institutional independence, religious institutions too have the right to preserve their institutional independence, which is specifically provided for under Article 26. So these are the broad contours of the issues. I'll just leave it at that. I'm so grateful for Mr. Khera's patience. I'll leave it to him.
Thank you, Sai. And we'll definitely come back with some of the basic queries which comes to a common man's mind. But before that, if we can request Mr. Shiv Khera to also give his perspective.
Sai, thanks a lot. As always, I've heard you before on the television, and every listening to you, it's enlightening, and I'm grateful. I only spoke to you once, and I couldn't agree with you more. I think no matter what you said is ditto already with me as I'm concerned. And Justice Joseph, thank you for sharing the platform, sir. I'm grateful to you. The work that you've done for the underprivileged, I'm grateful. And Justice Shankar Prasad, of course, great respect for them. And dear Neeraj, thank you very much. Now, look, you guys are expert on the legal side. I'm a common citizen. I'm talking from my side, from the perspective, so just bear with me as we go along. Now, we talked of religion, and Sai, you need to help me out a little bit because you did file suits in the courts, and we want to bring parity onto the religion. And when we talk of equality before law, do we really have the equality before law, which is what the secularism is talking about. Now, 400,000 Indian temples, the Hindu temples, they are paying all the revenue is being collected by the government, which comes to about 100,000 crores, 1 lakh crores a year. And that money goes all the way, which means the Siddhi Vinayak temple, which gives a large amount of revenue, has all the money going to the temple, where the neighbor, Haji Ali, doesn't pay anything or doesn't give anything. Pushkar temple in Rajasthan, all money goes to the government, and the Ajmer Sharif, nothing goes from there either. And the same thing is true everywhere across the country. Vaishno Devi, they have to pay everything to the government, but Hazrat Ali, nothing goes from there. So why is such a disparity, which when we call ourselves secular? The question is, are we secular? We are only secular in letter. We are not secular in spirit at all. Absolutely not. And I say it very strongly, and I believe it, and I would be more than happy to protest against it, because we are into trouble on this one here. Now, that's one part. And the second part is, yes, democracy is being protected by the judiciary, which is our judiciary, and it is better than many, many, many other countries as it is. But let me share with you one more, and we are the largest democracy, but we have to ask ourselves, are we a good democracy? Are we a good, yes, largest we are. Are we a good democracy? Now, why do I say that? You see, we have an office in Singapore, and I met a gentleman who was a very senior person in the government, because the Prime Minister of Singapore made a statement that 50% of the parliamentarian in India, they have criminal records, and some of them criminal records like murder, rape, and so on. And he asked me, is that correct, the statement made by my Prime Minister? I said, go ask your Prime Minister, and besides, I don't think your Prime Minister is going to make a loose statement. And I said, yes, whatever I have read in the papers and the media, the answer is absolutely, it is correct. But then he said, what about the judiciary? If the judiciary had done the job right, could you even get one criminal in the parliament? You know something, I hung my head in shame. And he's right. If your judiciary had done the job right, could you get even one criminal in the parliament? Folks, let us face it, who betrayed the country first? We need to ask. And unless we are willing to face the facts, we will just put our head in the sand and just keep saying we are the greatest democracy. And I'll share with you an example right here. Almost about 15, 20 years ago, I was a petitioner in the Supreme Court on Nota. And I had requested that today all the elections that are done in, people go and vote either on caste or religion or something else. And they have criminal records, and you go out, all the candidates that you see, you don't even like any one of them. They have criminal records. Now, what do? Either you vote on caste or religion, or vote for the weakest criminal. And you make the weakest criminal win. Now, the weakest criminal won. Now he's got power. Now the weakest criminal has become the strongest criminal. How do you like that? What kind of a democracy is this? So I had filed a petition in the Supreme Court that there must be an option of nota, none of the above. And it should be treated as a candidate side. And I said in there that if nota gets more than 50% of the vote, then all these candidates should be disqualified from that one constituency only for that one election and one upcoming election. Automatically, it'll open the door for honest, good people to come in. That will bring good democracy. Do we have democracy? That is the big question. So when we talk of activism of Judiciary, well, they are selectively active. I repeat, otherwise you could never get this many criminals in the parliament. I repeat, selectively active. So we have to start looking at it again one more time, and you people are experts in what we are talking. And let me share with you, I say that very clearly, very selectively active. Look, a few years ago, Shanti Bhushan had filed a affidavit in the Supreme Court that 8 out of 16 Chief Justices of India are corrupt. He had given their names, and nothing happened, and the whole file was pushed under the rug, and he's standing outside, no contempt of court. How do you like that? He was the ex-former law minister of India. He's not a guy running on the labor on the street. What kind of probity are we talking about? This is called selectively active, selective activism. Folks, we have to start looking at it. If we are really custodian of the democracy, we have to start looking at it number of ways where we are heading towards. And if we don't do it, we are in deep trouble. And the things that we said, that our Constitution guarantees and Constitution guarantees that, we have had 105 amendments to it. Now you might say we are evolving. American Constitution is amended only 5 times so far. But the point I'm trying to make is that somewhere we need to bring probity into our system. Otherwise, we are in deep trouble. Otherwise, the custodian, judiciary, does not remain a custodian. And let me share with you one last thing here. In fact, it happened when the Supreme Court on Prashant Bhushan had brought some kind of a contempt and so on. And they had invited a few lawyers in the TV program. And I was also on the panel. So at that point, I did use this word selectively activism or selectively corrupt. They said, are they corrupt? Selectively corrupt. And this was something that a senior advocate told me. And I asked him, are they good, honest people? And there are some good, honest people, don't get me wrong. There are some very good, honest people. But I said, are they really there? And you know what he said? He said, Shiv, they are selectively corrupt. I said, what does that mean? He said, well, they have a few pet lawyers through which they work out. And besides, when the money is really large, 200-300 crores, then, you know, they get tempted. So I said, don't say then they are honest. The price is different. Are you with me? They are not honest. The price is different. Just the way we trade, our price is different. People sell their bodies, the price is different. They cater to different markets. Folks, if we really want to be custodians of democracy, I think it is high time to look at the probity of our judiciary, because they are the first ones who betrayed the country. Otherwise, you will never have this kind of people in this. And I've shared the platform with some judges also. In fact, one more PIL I had filed that there must be a witness protection plan in this country, because 90% of witnesses run away. They run away. They withdraw their statement. What happened? Nobody says a word. And at that time, I have to mention that Justice Khare threw my application out, and it was dismissed. And then he was sharing the platform with me. And the first thing he said, we should have a witness protection plan. I said, what happened? Why did you throw it out? They talk different language after retirement. They talk different language when they're sitting there. I think we need to bring probity right in the system. Otherwise, there is no custodian of democracy. Otherwise, we're all in deep trouble. That's all I can say. I said, sir, pick it up and take it right from here.
Thank you, Mr. Khera, for putting very candidly the perspective from a common man's view. Yes, we all know, we are all a part of legal system, and these kind of perspectives are there in a common man's mind. Be that as it may, coming back to our topic and not diverting too much from the topic, I'll want to now request Justice Kurian Joseph on one particular aspect. Justice Joseph, Sai was mentioning about the legislature to take a lead in circumventing the reforms in a religious practice. Now, a question which I would, as a neutral person or a devil's advocate in me, would ask, what if the legislature of the country is not bold enough to confront with a particular religious practice, which is a legislature would always be governed by majoritarian votes and majoritarian views, and therefore it would not want to go with a practice, and it would always want, and in some uncertain terms, it would always want, even if it would want to do a particular thing, to come from Supreme Court so that it can go and say, sorry, we didn't do anything. The Supreme Court said that this is a wrong practice and therefore we have abolished. So therefore, with that kind of a perspective, constitutional morality as a particular subject, yes, we all know legislature is also under that constitutional morality. But when the legislature fails, I would say that, yes, we are fortunate enough to have a judiciary. When the legislature fails, it comes into place and it bars a particular practice. I would not be dwelling into the areas of what kind of practices have been barred. But yes, we all know there are practices, something like triple talaq. Even the females of a particular religion were happy with that being barred. So therefore, I don't think today anybody who's neutral and who's very, I would rather say, not going on to the religious part of it, would appreciate the Supreme Court coming down and invalidating triple talaq. So therefore, in today's world, when the legislature fails on its constitutional morality, as a common man, as a common citizen, I would always welcome the Supreme Court coming down heavily and utilizing the constitutional morality that the Supreme Court owes to the country, and using that, because these are some unpopular decisions, and unpopular decisions can never come through the elected legislature. Sir, to you.
If you give me 1 hour, I can answer all these things. But just to tell you, I'll just show you, this is the whole American Constitution. Just 7 articles. We have 395 articles in the Constitution of India. And then Mr. Steve, it has undergone 27 amendments so far. But doesn't matter, it makes no difference. But it's not as pliable as Indian Constitution for amendments in the court of the people. See, there are 2 courts. One, the court of the people, where we elect and they decide the policy. Whereas we have a non-elected, as Sai rightly said, appointed people. What is their duty? What their duty is only what the Constitution says about the law that is made by the elected people, and what the action the elected people's representative, that's called executive, they do. So judicial review of administrative action is alone the duty of the appointed people, the guardian of the Constitution, we call the judiciary. Their duty is not to make policy. I give a classic example on Mr. Schiff's own what they call experience about Justice Khare. Justice Khare, as a judge, he was right, saying that, you know, because it is not his duty to legislate on witness protection. It is the duty of the legislature to make a law on that. And a judge's duty to see whether that law is correct or not. But having said that, I tell you one thing, Mr. Shiv, I don't escape from that. Vishaga came only from judiciary because there is a vacuum.
Correct.
And all these environment protection laws, government came only from Supreme Court because there is a vacuum. So that's why I said I just started in the way there is a passive legislature and a passive executive, and when there is a constitutional mandate to see that the citizens' rights are to be respected, protected, and promoted, this is required. Only there, that's the only way, that's the only window open to the judiciary to step in. Otherwise, not. I fully agree with Sai. They said, you know, it's not because there's no debate in court. Debate in court is only the arguing counsel adversary. But whereas in the elected people, they have a floor to debate. But unfortunately, as the general pointed out, 20 legislations being passed in 5 minutes, I cannot even think of what sort of legislative duty they are doing it. Having said that, let me also say this right to practice religion is not an absolute right. It is subject to 4 restrictions. 1, public order. 2, health. 3, morality. And 4th, the other fundamental rights under Part 3 of the Constitution of India. So these 4 restrictions are also there on many fundamental rights, even on this freedom of speech and expression. It has in fact 9 of them. It is subject to 9 such restrictions. So there's no right which is so absolute and unbridled or unguided. All rights are subject to certain reasonable restrictions. So court's duty is only to see whether the legislature in its policy and the executive in its action is constitutional or not. And I happen to be the one who wrote the triple talaq judgment. The majority judgment is ordered by me. Sai, I tell you, left, see, in South we have a saying, if there is no, there's no other way, the dog has to bite. Because dog is not to bite. Its only duty is only to bark. To bark, why? It barks only to draw the attention of its owner. That there's something wrong, going wrong. You have some danger. But the owner does not get up out of his slumber. Then it is pushed to the wall. It has to bite. So that was the bite that was given by the Supreme Court of India, because it was driven against the wall. Because the political executive, they may be very shy. Grover is right, because on sensitive issues, they would like to put it on the on the shoulder of the court, saying that it is not who decided, it was Supreme Court decided. But on matters which they are not able to eschew, they will say, no, it is our right, you cannot do that. On this, Mr. Shiv, on these criminals coming to the executive on government, the Supreme Court, in fact, said so that you cannot. In fact, I was member of a part of that constitution judgment in Manoj Narula, where I said, a person against whom a criminal charge has been framed in the court, that person shall not contest an election. And Supreme Court went a little further on conviction also. But that was unanimously struck down by the parliament, by all parties. None opposed. It is we who fail in our duty. Look at the Indian democracy. Indian democracy, is it a real democracy? Because the average voting pattern is only 55%. So 45% of the people do not participate in the democratic process. So there is no actual democracy living in the country. And people, it's our fault. It's my fault. I don't vote. If all of us have voted, the right-minded and right-thinking and duty-conscious people and law-abiding citizens and law-respecting citizens would have come to the to the position of lawmakers, and from them, law executives, or rather the executive would have come in. Thank you.
Thank you so much, sir. I think
I did not complete. As after retirement, Justice Kare was entitled, because he's a member of the public then he was entitled to say so. As a member of the judiciary, he said, it is not my duty. But when coming to the platform as a public, yes, he has to say, because he has only alerted the duty of the lawmakers to make an appropriate law on that.
I
Yes,
can
Mr.
see Mr. Khera being...
May I have your permission, sir?
Yes, sir.
Okay. Sir, you did mention about the elected representative that the guys elected. My point is, and then you also added that 55% people vote, the balance don't vote. And I understand what you're saying about. But my only contention is that many times people have a dilemma. All candidates, they are not qualified, and many of them have criminal records. You tell me, who do they go vote for? Many people abstain from voting only because their only one thing is, who do you go vote for? If you don't go to vote, you are not a good citizen. If you go to vote, who do you vote for? Therefore, you vote for caste, religion, or you vote for the weakest criminal. Now you made the weakest criminal win. Now he becomes the strongest criminal because he's got power. Now look at this. Question is, everybody went to vote. Did you want him to win? Does he represent you? What are the answers? Answers are absolutely incorrect, none of the above. So with the Supreme Court, we requested the judges, and all they did was nothing. And they said, add the word none of the above. So even if now 60% people go to vote for none of the above, nothing happens. What a joke. It's a toothless judgment, sir. I mean, if they were really concerned for the country, they would say, all right, my friend, this is right to reject. Countries overseas, they have right to recall. We want to have a right to reject. If you do, you will get the right kind of representative in the system. And if till you get the right people in there, you will not get the right laws. I mean, this, I don't have to say that. We all know it, and we can do our best, all we want to do. It takes 25 years to clear one case in the Supreme Court. People said they should be given right to speak and they should be given right to present themselves. And I was talking to the Tulsi, and I said, 25 years it takes them to, by the time, even if you have the right to go present, keep presenting your case. 25 years it gets decided. Oh, come on, generations pass like this. Sir, I think we need to introspect. And as if now, even now, 35% of the judiciary seats are lying empty, vacant for the last 15 years. Tell me, what kind of constitution is this? I mean, is this not terrorizing our own citizens? I'm using the right word, sir. This is really terrorizing your own citizen. You protect the criminal and you penalize the honest person. What kind of judiciary is this? Sir, I think it is time that we need to introspect and look at ourselves. Really, introspection days are gone. We have to act and become activists. That's about it.
Thank you so much, sir. Again, I can surely see the common man's frustration in what Mr. Khera says. Coming back to Sai, my only thought in this entire discussion now would be that ultimately, the same question which I put to Justice Kurian Joseph, if the legislature fails to act, as General Shankar Prasad was also pointing out, today we see no debates happening in the parliament. We see legislations going around in minutes. Ultimately, the other side is not being shown. So therefore, ultimately, those legislations are coming back to the discussion that we are in. I would say that insofar as constitutional morality of the Supreme Court is concerned, insofar as the self, I would say, control, where does it, that's a very fine line of difference. Right. Ultimately, the lawyers like you will have to come into play to show the expert opinion also. Can I request the others to please mute? So what I was looking at was that ultimately, for a progressive country, yes, we all know that there are some practices which may, I'm not saying which practice, there may be, and I'll not be surprised in times to come if tomorrow there are PILs in the Supreme Court to restrict certain slaughters as religious practices, or for pollution to restrict the kind of funeral pyres that come in. There are trees being burned. So I don't know where after 50 years we'll go. Supreme Court may be faced with a situation tomorrow that all funerals should be only by electric, not by the pyres. So these are the difficult questions which certainly will come. And at some point of time, the Supreme Court will also have to balance out the pollution aspect, the tree aspect with regard to funeral pyres. So I'm just opening a very, very broad mind. So therefore, where do you see that today's Supreme Court I'm not mentioning to any particular era. Today, when I say it's the 10-year gap, so today's Supreme Court, where do you see it going wrong? It may be wrong with a particular perspective on a particular judgment, but do we, if we don't expect this from the Supreme Court, then where do we expect it from?
So there are three levels of responses. I think it's a very valid question, which is, to borrow Justice Kurian's words, if the watchdog is expected to do its job, then the master must do its job. But if it doesn't, then the dog perhaps has to bite. Okay, I completely get that. Okay, but let's do something. If the dog does not do its job, does the master get to bite the dog? Which is to say, if the judiciary fails to do its job, will the legislature and the executive have an equal right in saying what the judiciary must do? Because then the question is going to be, who decides if the judiciary has superior powers insofar as others' terms are concerned, whereas the others have limited rights as far as the judiciary's territory is concerned? That's a legitimate question. So for instance, close to 80,000 cases pending before the Supreme Court as on date. Alone in the Supreme Court, okay? And then you're looking at about 4.5 to 5 crores in the rest of the country. And several high courts have lots of pendencies. And fine, I think there are legitimate concerns about 50% occupancy rates of high courts, where let's say judges, courts are operating at less than 50% strength. That's a very valid concern. Now, with all this going on, can the legislature say, look, I don't think you seem to be doing a good job of your mandate. Why don't I step into the picture and ease your burden? Would that be okay? Now, why is this important? During the course of the arguments in the marital rape petition, one of the arguments that I had to make, and I'm not going to argue on the marital rape issue here because that would be wrong, so I won't do that. But the question of principle that I want to present is this. There's a fantastic judgment called Government of Andhra Pradesh versus P. Lakshmi. Please read that judgment. I think it's a Constitution bench judgment. Paragraphs 31 to 52 of the judgment. Fantastic judgment on why the tyranny of the unelected should not be permitted. These are languages and words of the Supreme Court and the Constitution bench of the Supreme Court. Basically saying, what is it that the legislature is meant for? For social experiments, for policy-based experiments, which is to say, let the society find in itself the voice and the courage and multiple movements to come out with the right solution. And if you don't do that, and the judiciary starts taking those powers, what's going to happen is that the scope of exercise of powers by the judiciary will gradually enlarge, which is what has happened. I say this bluntly, which is exactly what has happened. I've said this in court as much in this matter. That what has happened over the years is this. Now, in the 70s, it made sense to basically say there is a majoritarian government or there is heavy corruption, therefore public interest litigation and epistolary, let's say, litigation by Justice Bhagwati and Justice Krishna Iyer was necessary, where even letters were treated as writ petitions. Is it truly our case that in the last 35, 40 years, regardless of the party in power, that's still the case? Is that truly the case? Now, who decides whether the situation has changed? Will it be self-certification either by the judiciary or by the legislature to say, situation has changed, so can you stop being activisty? Who's going to say this? People have to say this. People have a right to say this. People have the right to say this without the sword of contempt of court dangling over their heads. To basically say, look, there is a point where this is not a question of three different organs dividing territory and turf between them, saying, ye tumhara ilaka hai, ye mera ilaka hai, ye road aapka hai, ye road mera hai. No. It is a question of participation of the Republic, and Republic means people, as part of the policy and rule-making process and law-making process. So while I can certainly be happy about the fact that as a lawyer, the organization or the institution that I participate before has greater powers, as a citizen, I should be extremely sad that this particular organization's scope of powers is increasing at the expense of everybody else. And it's not about the legislature or the judiciary, or let's say, or the executive, but who they represent, the people. I'll give you a simple example. Your point was, shouldn't trained lawyers have the confidence to speak on the subject of religion? I think it's not a bad argument to make at all. Hinduism is not just one religion, it is an agglomeration and ocean of sampradayas. Can I really hope to be an expert on everything under the sun? I am a practicing Shaivite. At least that's my legacy. That's the lineage I come from. I can't hope to even understand Kashmir Shaiva, let's say Shaiva Siddhanta. Forget Vaishnava Siddhanta. Shaivism itself has so many schools of thought. Only yesterday, my junior from the chamber educated me on the fact that Lord Hanuman, who is otherwise seen as a celibate deity, is married. That there is a consort of Lord Hanuman by the name Suvarchala. And that there are temples in Andhra Pradesh dedicated to both Hanumanji as well as his consort, specifically worshipping this form of Hanuman. How many people actually are aware of this? So look at the sheer layers available in one school of thought, in one sect. Okay. So predominantly the position is, I understand that there is always a balance to be maintained. But should you be happy, or should we be happy at the scope of expansion of one particular institution's powers? I think we may end up diluting another basic feature of the Constitution, which forms part of the basic structure, namely doctrine of separation of powers. If today it is our case that one particular feature can be violated to some extent because the ends justify the means, well, why shouldn't I violate secularism for certain other end goals? What stops me from violating secularism or any other aspect? Who stops us from doing that? The point is this. My principal position over the last 5 years has been, do not worship the Constitution, apply the Constitution. Don't treat it as a religious document, because at the end of the day, it is effectively the product of its circumstances, and it represents a certain decision or a social contract taken at a certain point of time by the people. So while you may want to retain certain immutable aspects to protect what you think is the spirit of Bharat, fine, that makes a lot of sense. You should certainly not deify to such an extent that you run down the confidence in people. The health of a democracy is not determined by the health of the judiciary, but the confidence that the people have in their own ability to come out with corrective mechanisms through the legislature. The judiciary effectively is the option of last resort. If a judiciary is hyperactive and activist, it does not demonstrate a healthy democracy. It shows a democracy on the verge of deterioration and degradation.
Absolutely.
So, which is why the cynicism that we typically air with respect to the legislature and executive, you have to tell me, why should the same degree of cynicism not be applicable with respect to the judiciary in light of so many instances? And with a learned member of with a former learned member of the judiciary here, with all due respect, one question. If a body believes that it is completely beyond the pale of reform to protect its judicial independence, it certainly puts serious question mark on its ability to talk about reform of anybody else. If you think you're perfect and you're final and there is no scope for reform whatsoever, what stops any other body from making the same statement and say, as long as you're not open to reform, kindly do not tell us that we should be open to reform. The day you think you're open to introspection is the day you get the right to speak of somebody else to introspect. Because I'm sorry to say, in a democracy, the first principle is a two-way street. Everything is a two-way street. What you're happy to dish out, you must be happy to take. In this particular regard, I certainly believe that an activist judiciary is an exceptional, extraordinary option of last resort. But the moment you realize that the situation does not warrant the exercise of such extraordinary powers, since the judiciary is independent, it must itself cede space. That is the only way that this reticent body can regain trust and the confidence and respect from the people. Because the judiciary has no way of reaching out to the people except through its conduct and judgments. So the only way that it can inspire confidence in the people, that this body has a right to tell others to stay within their territories, because it is the first body to respect the lines painted by the Constitution as far as its own operations are concerned. The day that happens, automatically I think things will become different. But there's one sensitive aspect that I think we must broach, which hasn't been broached so far. I think it's time for us to openly recognize that even as far as the judiciary are concerned, there are ideological positions which they're entitled to take. Accept it and use it, as opposed to saying that it's all objective, it's all neutral. Which human being is positively neutral or objective? It's not happening. So you might as well be allowed to present your position and justify that particular position. And in a free market of ideas, let there be a contestation of ideas so that people can see. if you're happy to look at America for certain precedents from Article 14 to whatnot, America has a clear concept of conservative judges and liberal judges. You might as well have a similar concept here as far as Bharat is concerned. What is the point of beating around the bush and behaving as if there is absolutely no ideological bias? A sitting Chief Justice of the Odisha High Court, who I have deep respect for, has openly made the statement that we must acknowledge the contribution of leftist lawyers to the Constitution. If that is his position, well, at least there is an admission that there is a left bias and a right bias within the judiciary. Fantastic. Then let us all have an open contestation of ideas. So I think it's very, very important for even these sensitive aspects to be addressed, because I don't think you can address them in silos. Activism of the judiciary is not a discussion that can be had independent of accountability of the judiciary and introspection of the judiciary. I think all these discussions must go hand in hand.
I see Justice Kurian Joseph's hand raised. So we are into some interesting discussions. Justice Kurian Joseph, I would invite you to.
I know it's time for you to close also. I only wanted to say, I 100% agree with all the observations made here on the need for judiciary to introspect. I always say, when the judges on the podium, they say the sky is our limit. I say, no, you should also be aware of your limitations. Limit is something which you can always be proud of, but limitation is something which you should be aware of. This awareness of the limitation is more important than your idea of limits. That's number one. Number two, all said and done, the substratum of any judgment can be taken away by a legislation in the parliament, which we must know. It's not as if this is the final word. This final word can be removed, obliterated completely by an appropriate legislation, either in the parliament as far as the central law is concerned, or in the state where it's application of the central law in the state, or a state law is concerned. So because we have a state law and a central law, that's what I'm saying. So that is actually possible. So I just wanted to comment on Mr. Shikhera's one comment that is actively selective. And I would also
selective activism.
Selective activism. I also wanted to add one quibbling remark to it. Seeing my institution now, it is selectively active.
We had a very good discussion. I would just want now, because we have Sai on our panel and we all know about his recent book. So I would just want Sai in one statement. I know this is beyond that, but what is his stand on India, that is Bharat, so that we, at least the Vasant Viharis today, also get to know of that principle.
So I think the central message that I have tried to convey through the book is that Bharat has certainly adopted the Upanishadic principle of taking the best of ideas wherever it comes from, without the need to get into origins. However, that should not come at the expense of looking at your own indigenous philosophy and your own contributions. Given that this is a country which is fundamentally worship knowledge, and it has a huge repository of knowledge structures and legal structures and philosophical traditions, from legal education to practice, my entire point has been, why is it that our courts are so comfortable looking at principles of common law from UK? Why aren't we looking at our own principles of justice, at least with respect to tortious litigation and torts, where equity and justice can be, you can find, let's say, reasonable corollaries, or let's say reasonable corresponding concept as far as Bharat is concerned. So the point, I think, has been, perhaps it's time to shed this self-loathing attitude as far as Bharat is concerned. And the reason why I've used this particular title is that I believe that Bharat suffers from multiple personality disorder. Okay. And identification of its personality or its identity does not, should not, and will not come in the way of accommodation of any religion or any other identity. Because even before you had a constitution in place, I've said this over and over again, an a-constitutional, so-called pre-modern Bharat has welcomed Jews and Parsis in this country as refugees without insisting on religious conversions. So therefore, the constitution is what it is because that is the innate spirit of Bharat. And therefore, I wouldn't use the constitution alone as the touchstone of what this civilization is. I think the civilization far outstrips and outranks the constitution as far as its age and experience is concerned. So the central message has been, थोड़ा अंदर झांक के देखिए, अच्छा भी है बहुत देखने के लिए और सोचने के लिए।
Thank you so much, Sai. I would, on my part and on behalf of Vasant Vihar Club, thank you all. Before I hand over the stage to our president, General Shankar Prasad, to give a vote of thanks.
Thank you so much, Neeraj, and thank you so much, Justice Kurian, Sai, and your friend Shiv. You know, there are a large number of questions in the chat box, and I think you all have access to the chat box, so you could read those questions. And some of them are really, really very valid and intriguing. I don't think we have the time to go through those questions. And I would apologize and say sorry to all those people who have taken trouble to write. But I do request that the participants today, Justice Kurian, Sai, and Shiv, could read this question. Are these questions available to them as well? In the
Yes,
chat
we can read them, sir. Yes.
So it will not be a bad idea if you reflected on them and gave us a feedback if you think any of those require a feedback to Neeraj, and Neeraj can then communicate to rest of us. We have really overshot. But you know, the interesting part is this particular discussion can go on till tomorrow morning. And yet people will not be fully satisfied because everybody has an opinion. And as Justice Kurian said, that you're addressing a bunch of audience who are very inquisitive about things. And one great statement somebody made, one of you, is the judiciary really independent? I mean, somebody said judiciary is independent. Is judiciary really independent? Who appoints the judiciary? And why are these judgments reserved all the time? So these are some basic questions that a lot of people want to ask, but I'm so happy to see that this particular program has been seen by over 100 people, and each one has got a view. Each one has got a question to ask. If you go through the questions, they're very insight questions, very incisive questions. So just look at these questions and see if you want to respond to them. Once again, on behalf of all of us in Vasant Vihar Society and the club and all of us who live in Vasant Vihar, thank you so much, each one of you, Justice Kurian. Thank you so much for being here and spending over an hour and a half with us despite your very heavy schedule. Jay, I think your stock has gone up a hell of a lot in Vasant Vihar. You've made some excellent exposures. A lot of us were never really with the religion and the activism of the judiciary. But you put lots of things in perspective, and I think a lot of us are thinking about what is the status of hijab and what is the status of Sabra Mali and what's the state of various other issues. And of course, why isn't there one common law and why should there be various kinds of laws, what do you call it? Muslim personal laws and all that sort of stuff. So those are issues that we can go on discussing, but they're interesting subjects. And Shiv Bhai, you have been absolutely brilliant, which is why you are here. And which is why Neeraj accepted you to be here, because the choice was dependent very much on Neeraj. And he knew that you will come out with ideas which a common man really wants to talk about. So Shiv, thank you so much for bringing the point of view of a common man. We are very grateful to you. Justice Kurian, thank you so much. Sai, thank you so much. Shiv, thank you so much. And Neeraj, above all, thank you so much for putting this together. We will do more of these legal issues because everybody seems to be interested in these legal issues. And we have a lovely set of people will participate in it. And thank you so much, Sanjana and Benita, for putting this together on the Zoom. I'm so grateful to both of you for all the time taking time to do this. Once again, good night and thank you so much.
Thanks to the Vasant Vihar Club for organizing a very meaningful discussion.
Thank you very much.
Absolutely.
Thank you for being here.
Thank you, all of you.
Justice.
Grateful. Thank you.
Sir.
Thank you very much. And before
Have a
we
good
sign
night.
off,
Yeah.
I would
God
just
bless.
like to
Thank
say
you.
that please remember to join us at 6:30 on the 16th of March when we discuss a book, Birth of Bangladesh. I'm sure that's going to be an equally scintillating evening. Thank you and wish you all good night. Bye-bye.